Hello, everyone. I am Elizabeth Samples. I'm a partner in Husch Blackwell's Healthcare, Life Sciences, and Education group. Welcome to today's webinar. Just by way of introduction, I'm in my 10th year with Husch's Education Practice Group. I serve educational institutions in various areas of compliance, supporting colleges, universities, and schools with day-to-day counsel, investigations, hearings, training, and policy and system development. Prior to joining Husch Blackwell, I was an attorney with the U.S. Department of Education's Office for Civil Rights, so a significant portion of my practice focuses on assisting clients with all facets of civil rights compliance under Title IX, Title VI, Section 504, and the ADA. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for use during the program today. If you have any questions during the webcast, please feel free to submit them via the question box. We will likely be pressed for time, but we will try to get to any questions as we are able. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. For live attendees, you can report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and viewing. Towards the end of the program, be sure to complete our short survey. We use your feedback to plan for future programs that are applicable to your business needs. I'll also note that this is a particularly challenging topic to discuss presently, given current DEI initiatives and state laws in response to them. And so if you have any feedback for us in terms of content related to the presentation today, please feel free to submit that via the survey as well. We're always trying to improve and be more accurate and inclusive. And so if you have anything that you'd like to share with us by way of feedback, please use that survey as a tool to do so. That is all for the housekeeping items. So let's get started with our program. Joining me today in studio is Taronda Randall, and from Chicago is Catherine Tierney. Taronda is an attorney in our Healthcare, Life Sciences, and Education group. She provides college and university clients with a comprehensive understanding of challenges associated with collegiate athletics. Taronda brings invaluable experience to her private practice, having served in athletic departments of major public universities and as a postgraduate intern with the NCAA. Catherine is an attorney in our Healthcare, Life Sciences, and Education group as well. She is an education-focused attorney who has worked with clients ranging from early childhood educators to colleges and universities, as well as to the businesses that serve these institutions. Her practice encompasses litigation, investigations, and regulatory compliance. And both Taronda and Catherine have taken a keen interest in DE&I initiatives and efforts across campuses and have educated themselves in the way of DEI efforts and how that might be impacting our clients. And so very happy to have them joining today. So let's talk quickly about our learning objectives. Catherine's going to start us off with some DEI language coverage and an overview. And then she's going to talk about OCR enforcement activity and some related Department of Education and Department of Justice guidance. And then Taronda is going to cover some relevant case law for us, including Students for Fair Admission case from last summer. And then I'll conclude the webinar with an overview of challenges and changes related to state law that we're seeing, and then discuss some current topics. So with that, we want to start by just getting a sense of who's in the virtual room. So our first poll question, I am a higher education administrator, an attorney, a DEI professional, or I wear too many hats to choose. So if you would please just submit your response to our first poll question. I'll give just a minute or two to let some of the responses come in. Okay, we have nearly half of our attendees responded. So let me go ahead and Okay, so we have about nearly 40% higher education administrators, about the same percentage attorneys, DEI professionals, and then typical for higher education practitioners and those affiliated with it, just about 20% of you have said that you wear too many hats to choose. So again, thank you for joining us today. And with that, I'm going to kick it over to Catherine.
Hello, everyone. Thank you so much for being here. To get us started today, I'm going to talk a little bit about some DEI language and just give a bit of an overview so that we're all on the same page as we move into some substance here. So starting off, we at Husch Blackwell use the term DEI. We're talking about diversity, equity, and inclusion. Diversity talks about the various identities of the people within a room. Equity talks about the support those individuals need to succeed. You can see this pretty familiar graphic on our slide here. Right? Equality is the idea that everyone gets the same thing versus equity is the idea that everyone gets what they need to succeed. And then inclusion talks about the idea of how people feel welcomed into a space and actually integrated into a community. You might hear other phrases referencing a similar concept at other institutions. So people use DEIA talking about acceptance, DEIB talking about belonging, or DEIJ or JEDI talking about justice. We acknowledge all of those rules here for ease. We use DEI in our language, but that's kind of what we're talking about today. Moving right along, when we think about the D in DEI diversity, we're talking about diversity across a number of identities. This inner circle in the dark blue represents some of the identities that often get considered in the DEI space. So gender, race, ethnicity, sexual orientation, age, and physical abilities or qualities. But this outer circle reflects additional identities that are often not considered, but they do contribute to the diversity of our communities. That includes things like education, parental status, military experience, and socioeconomic status. So those are just some of the identities that we're talking about when we consider diversity. There are a number of emerging trends in the DEI space, and we want to touch on some of these DEI affirming trends in employment. We are going to talk about some anti-DEI trends in the higher education space as well, but we want to make sure we're also highlighting some DEI affirming roles. So examples of DEI affirming trends fall into external, mixed external, and internal categories. External trends include an emphasis on activism in the shareholder space and a focus on DE&I in procurement. Mixed internal and external trends in the DEI space include a war for talent. Many potential employees are seeking institutions, employers who prioritize DEI. So where that's possible, that's often viewed as a competitive advantage. And then internal trends include expanding the definition of diversity, kind of as we talked about before with the wheel, and also using data to measure inclusion to see exactly what is effective in bringing community members into feeling like they are valued and belong. Moving right along here. So in institutions that are legally permitted to prioritize DE&I, there are a number of best practices which can support diverse communities. Examples include leadership support and institutional top-down buy-in. One way to embody this is to appoint a chief diversity officer. So someone in the C-suite who's really is in charge of emphasizing the importance of diversity and prioritizing that. Continuing on, maintaining a DEI team, either internally or using an external consultant for this role, is a great way to implement an effective DEI strategy. Using data analysis and transparency is also very useful. So data can create accountability, measuring the effectiveness of a DEI program and understanding the gaps and informing opportunities for the future. We will caution that you should not use data as part of an employment action in terms of decision-making or influencing employment decisions. So we should not be developing quotas, right? That's not permissible. The rule of thumb for this is the closer the DEI goal is to an employment decision, the greater the legal risk is. And that's something you should, of course, navigate with an attorney. And then continuing on with our effective strategies, creating a communications toolkit is really important. A lot of times, particularly in spaces where DEI is valued, we might not always be collaborating across institutional branches. So phrasing concepts is crucial. We want to define diversity both in compliance with the law and in compliance with our goals. So building relationships across legal and human resources and your DEI teams is really important. Furthermore, conducting DEI trainings is a really helpful element of an effective DEI strategy. You're all here, so it seems like some of that training is important. And then lastly is remembering that you have ongoing federal civil rights requirements, and auditing your practices is a really helpful way to do that. You can conduct narrower audits or broader audits, and working with an attorney to conduct those audits can be really helpful. That's something we do here at Husch and other firms do as well. All right, cruising right along here. So we've talked a little bit about the D in DEI. Institutions should also consider the I, which is inclusion. So evaluating the factors listed on this slide can indicate whether community members from diverse backgrounds are actively included. So we're looking at things like institutional trust, engagement, belonging, well-being, autonomy. There are measures for each of these factors, and by gathering that data, you can get a sense of inclusion at your institution. Finally, we're going to talk a lot about various laws which address equity, right? The E in DEI. These are some of the laws which impact equity in higher education and employment. We're going to dive into a couple of these in a little more depth soon. So before we do that, we want to talk a little bit about institutional anti-discrimination policies. Discrimination is materially adverse treatment based on or because of one's status in a protected category. A lot of federal aid programs require institutional anti-discrimination policies. These policies apply to campus communities, including students and employees. These policies are often viewed as imposing additional contractual obligations upon the institution. So when you're drafting these policies, you should make sure that the things you're promising are things you are able to deliver. And then additionally, many of these types of policies incorporate local laws and ordinances with broader protections than those required by federal civil rights laws. Right, moving right along here. We're going to talk a little bit more about equity. So we're going to talk about the Department of Education's Office of Civil Rights Enforcement. So what is OCR? It is part of the Department of Education, and its mission is to ensure equal access to education and to promote educational excellence throughout the nation through various enforcement, through vigorous enforcement of civil rights. OCR enforces Title VI, Title IX, Section 504 of the Rehabilitation Act, and the Age Discrimination Act of 1975. We're going to talk through each of those laws in turn. So before we do that, the Office of Civil Rights does enforce these federal civil rights laws that prohibit discrimination in programs or activities receiving federal funding. There has been a significant increase in OCR activity during the Biden administration, and there are several examples of OCR guidance regarding responses to discrimination and harassment claims, and we're going to talk through some of those as well. So when we talk about discrimination in educational programs or activities, what are we talking about? We're talking about lots of different things. You can see this list here, but it includes everything from recruiting all the way to student discipline. So we're really thinking quite broadly about what education programs or activities are, and that's kind of important context as we move forward into these laws specifically. Okay, and then the last thing to flag before we get into those specific laws is that OCR activity includes reverse discrimination claims. This is a phrase that is used to refer to discrimination claims that are asserted by individuals who do not traditionally belong to those marginalized groups. So majority groups can bring discrimination claims as well. These laws are not, targeted to specific populations. All right. So moving right along here, we're going to start with Title VI. Title VI prohibits discrimination on the basis of race, color, and national origin in programs or activities that receive federal financial assistance. This month, we checked from April 1st to the 24th, and OCR opened 11 Title VI investigations involving institutions of higher education, which is a pretty significant number. There have been some recent trends in this space. So in particular, there have been increased investigations relating to Israeli national origin. It's important to note here that Title VI does not explicitly cover religious discrimination, but we'll touch on how religious discrimination claims often interact with Title VI in just a minute. Additionally, there has been a trend toward investigating race-based scholarship programs. There is not a prohibition on scholarships for demonstrated commitment to a community based on race. So for example, a scholarship for a demonstrated commitment to the Asian American community would be permissible, but a scholarship specifically for someone who identifies as Asian American would not be permissible. And we'll talk more about examples of that as well. And then the last trend in this space is investigations into disparate discipline based on student race. So when students of one race are experiencing discrimination at a disproportionate rate. Sorry about that. Title VI regulation in particular flags that the recipient must take affirmative action to overcome the effects of prior race discrimination, and also may take affirmative action to overcome the effects of conditions which resulted in limiting participation by persons of a particular race, color, or national origin. So there is this opportunity to take meaningful affirmative action in this space. And we'll talk about, federal law that helps caveat that in various ways shortly. And then the last thing on Title VI is that the Department of Education on November 7th, 2023, released a Dear Colleague letter. And this letter specifically responded to the nationwide rise in reports of hate crimes and harassment, including an alarming rise in disturbing anti-Semitic incidents and threats to Jewish, Israeli, Muslim, Arab, and Palestinian students. And this letter helped explain that relationship between Title VI and racial and religious discrimination. The letter noted that although Title VI prohibits racial discrimination, discrimination against religious groups is also prohibited under Title VI, where that discrimination involves racial, ethnic, or ancestral slurs or stereotypes, when the discrimination is based on a student's skin color, physical features, or style of dress that reflects both ethnic and religious traditions, and when the discrimination is based on where a student came from or is perceived to have come from. So that kind of explains that overlap between religious and racial discrimination in that way. Moving on to the next statute, we're going to talk about Title IX. So Title IX prohibits discrimination on the basis of sex in programs or activities that receive federal financial assistance from the Department of Education. When we talk about discrimination based on sex, we are including biological sex, of course, but also gender identity, sexual orientation, and pregnancy. So we're taking a very broad look at that term. As I imagine many of you know, there were new Title IX regulations released on April 19th. It's about 1,500 pages. Those new regulations are effective on August 1st. Unfortunately, today we don't have a lot of time to dive into those specific regulations, but our firm is offering another free CLE tomorrow on the new Title IX regs. It'll be presented by Haley Hansen and Derek Teeter, who are lovely. So if that's something you're interested in learning more about, there's another free CLE available for you tomorrow. So that's Title IX, and now we'll move on to Section 504 of the Rehabilitation Act. The Rehabilitation Act prohibits discrimination on the basis of disability in programs or activities that receive federal financial assistance from the Department of Education. This is an interactive process for accommodation. So students and the institution should work together to figure out appropriate accommodations. This interactive process is really an opportunity to think creatively and problem solve for your students, for your community members, to make sure that you are providing resources that allow them to get that equal access to their education. One trend in the Section 504 enforcement has been consideration of remote work and distance learning, where such an accommodation was previously deemed impossible. You might remember about 40 years ago, everyone went online. So we learned that a lot of times it is possible to pivot to remote work. Just because an institution did pivot to remote work during the pandemic does not mean that they are required to do so for all accommodations. However, it has shown what is possible. And so as you are approaching this interactive process creatively, that is another option to consider. Continuing along with the Rehabilitation Act, this act and whom it covers is a little bit different than the other groups and than the other civil rights statutes that we've talked about. So a person with a disability, according to the Department of Education, is anyone who has a physical or mental impairment which substantially limits one or more major life activities, or has a record of such impairment, or is regarded as having such an impairment. So under the Rehabilitation Act, right, someone who is perceived as having a disability, even if they don't have a disability, is still covered under that act. As we were doing our research and reviewing topics for this presentation, we noted that a lot of the the federal government's language referred to individuals as handicapped. That is not a preferred term in this space. When you're talking about a person with a disability, you should either use the language person with disability or a disabled person. Both of those terms are, viewed as permissible within the disability community. It is very much up to the individual which term feels most authentic to them. And so if you're working and talking about a specific person, you should ask them what language they prefer. Okay, continuing on here. Lastly, we have the Age Discrimination Act, which prohibits discrimination on the basis of age in programs or activities that receive federal financial assistance from the Department of Education. The act covers people of all ages, and there are exemptions for certain types of programs that are specifically directed at children or the elderly, but otherwise we don't want to be discriminating based on age. So continuing right along here, it's important to note that the Age Discrimination Act does not cover discrimination in employment. That's the Age Discrimination in Employment Act. And so it's helpful to sometimes keep those things separate. Okay, so at this point, we've got our baseline covered, and I'm going to turn this over to Rhonda to continue presenting on relevant legal cases.
Thank you, Catherine. So relevant legal cases, we're going to start off with SFFA, Students for Fair Admissions versus Harvard, and SFFA versus UNC. So I know that a lot of you are familiar with the decision, but for those of you who are not as familiar, we'll discuss briefly the holding. So the Supreme Court held that schools may not consider race in determining student admissions. And it's important to note that when deciding cases about race, the Supreme Court uses a test called strict scrutiny. So in order for racial classifications to be permissible and pass the strict scrutiny test, the racial classification must do two things. First, it has to further a compelling government interest, and second, it must be narrowly tailored to further that government interest. Previously, the Supreme Court has held that achieving the educational benefits of having a racially diverse class was a compelling government interest. Several cases that they held that, we have Bakke, Grutter, as well as the two Fisher cases. However, in SFFA, the court held in the 6-3 decision that achieving the educational benefits of a racially diverse student body was not a compelling government interest. And the court justified its decision by using 5 different reasons. So first, the court stated that the admissions program was too vague for the benefit of achieving a racially diverse student body was too vague. It felt that it could not meaningfully define the value of diversity. Second, the court found that the admissions programs were both over and under inclusive, and there was not a meaningful way to show a match between the asserted benefit and the admissions program. So an example of it being over inclusive is that students who are Chinese American and students that are Indian American would be lumped together as Asian, even though their experiences could differ significantly. I always say that people are not a monolith, if you will. An example of under-inclusivity is that students with Middle Eastern heritage are often not even considered in racial categorizations at all. Third, the court emphasized that for schools like Harvard and UNC, admissions was a zero-sum process. So in the court's mind, this means that if race is a plus factor for some students, there's essentially a minus factor for others because there are a limited number of spots. This is not true, of course, for schools who are not as selective or are able to take all of their applicants. Fourth, the court found that using race in admissions relied upon stereotypes that students from certain races would have certain perspectives. And finally, the court stated that affirmative action would not have a logical endpoint. And I just want to point out that in the 2003 Grutter case, Justice O'Connor stated that 25 years, we probably wouldn't need the racial classifications that case upheld. So, of course, there's a little bit of nuance in the court's decision. The court emphasized that its opinion should not be construed as prohibiting universities from considering applicants' discussion of how race impacted their lives. It could be through discrimination, inspiration, or even otherwise. But the court also emphasized that universities could not simply establish through application essays or other means the regime we hold unlawful today. So in other words, the institution could not set up race proxies, nor could it consider race as a category of itself. So in response to SFFA, the Department of Ed issued a Dear Colleague letter on August 14, 2023. We're going to talk a little bit more about those resources later on, but I just want to point out that that Dear Colleague letter encouraged schools to examine their admission preferences, such as those based on legacy status or donor affiliation, anything that was unrelated to a prospect's individual merit or potential, and that could reduce opportunities for others. And the department emphasized the fact that it will continue to investigate allegations of admissions discrimination in that letter. So when you think about the direct and secondary effects of SFFA, so the direct effect, institutions cannot consider race itself as a factor in granting admission, except maybe, emphasis on maybe, to remedy the institution's own recent documented discrimination. And the secondary effect would be that they could not consider race as an eligibility factor in any of their programs or activities, again, except maybe to remedy their own recent past documented discrimination. I know a lot of schools are asking about other policies that might be implicated. For example, some schools are reviewing their testing policies and legacy admissions in light of this finding. So scholarships, programs, legacy admissions, those are all things that should be examined. And another area where schools have questions, and frankly, where litigation is already occurring, is what counts as proxy for race. Institutional scholarships is something else that we just kind of wanted to bring to your attention. It's kind of unquestionable that there's a benefit sufficient to trigger equal protection and Title VI analysis, if you will. So prior to SFFA, race-based scholarships were justified under the same benefits of diversity rationale that supported that use of race-conscious admissions. But certain specific federal statutes, as well as programs that authorize race-based scholarships, were deemed to control over Title VI. So it's important to remember that when it comes to institutional scholarships. So we have an example that we want to talk with you about. So an institution's Future of Hope Scholarship provides a full ride scholarship to students with a proven record of academic success in high school and who are either first generation college students or are from a select list of 6 high schools in the state that have the lowest percentage of graduates who go on to college. So when you think about that example, I want to launch a poll question, or so I thought. Maybe not. Maybe there's not a poll question there. Thought there would be, but there is not. But we'll talk a little bit about this because the poll question was going to be, okay. You have to love having people behind the scenes that can guide you down the right path because they were able to tell me that there is in fact a poll question. So we want to ask, is this scholarship program permissible under SFFA's reasoning? Yes or no? So give a few moments to allow responses to come in. I know we love polls, one, just to see what our audience is thinking, but also in order to get that coveted CLE credit, sometimes we have to include a certain number of polls. So we have almost half of our attendees who have responded. Give a few. Okay, let's see. So yes, 76% said that the scholarship program was in fact permissible under SFA reasons. So it's important to note that institutions, are not offering the race-specific scholarships. One way to support diverse perspectives without really offering a race-based scholarship is to, as Catherine mentioned earlier, offer a scholarship for someone who might have a demonstrated interest in serving a particular community. And the case is really clear on the fact that scholarship policies cannot work in place as a proxy for race, if you will. So you can't try to circumvent that requirement. Want to go back a few slides and talk about some broader DEI initiatives really quickly. So it's important to note that the ruling itself doesn't have any immediate impact on private employers. And race-based decision-making in the workplace has always been unlawful, but we say that if you have a really well-structured DEI program, it will not run afoul of any federal, state, or local discrimination laws. However, the Supreme Court has now, if you will, opened the door to and is made likely, as we see, more future legal challenges against private employers' DEI efforts. So SFFA doesn't prohibit efforts to recruit a diverse applicant pool, educational programs that teach the value of diversity, you will, in a private workplace, or efforts to prevent and address prohibited discrimination and harassment. So despite the recent challenges to DEI programs that we're seeing, we want to note that employers can continue to increase diversity in their workplace and set aspirational goals with respect to DEI without running afoul of federal, state, and local anti-discrimination laws. So some examples that we like to pull from SFFA that you should be mindful of in this context. We recommend that you avoid using quotas or set-asides when setting hiring or advancement goals. Ensure that you define diversity broadly, if you will, and really focus on removing the barriers for individuals in the hiring process. And as well as the hiring, we'll think about retention in terms of creating mentorship and pipeline programs that are open to all employees, and continue to provide the anti-discrimination and anti-harassment training. Of course, you want to review any internal and external communications that you have related to DEI and take all complaints of discrimination seriously. We want to make sure that even when you bring in outside trainers, something that sometimes people don't think about, you should be reviewing their content to ensure that they are, compliant with federal and state law.
And one thing, Taronda, I'll just mention, when we talk about ensuring defining diversity broadly, that's a good opportunity to kind of think back to Catherine's section and that identity wheel that she shared. Sort of looking at that as a way to sort of broaden these definitions of diversity from that inner circle that are typically associated with diversity, and looking, at some of those other kind of characteristics and experiences that might contribute to diversity on campus.
That's a really good point. So I know I mentioned the Dear Colleague letter. So the Department of Education and the department, the DOJ, with the guidance that they issue, the Dear Colleague letter, the Q&A, the materials have specific recommendations for institutions. We're going to talk about some examples, as well as some steps that institutions can take to achieve diversity. So when it comes to some recommendations from the materials, recruit and retain talented students from underserved community, including those with large numbers of students of color. You want to foster a sense of belonging for the students that you currently have, and ensure that any prospective students of color know that your institution is a place where all students are welcome and they will be given the resources to succeed, and provide students with need-based financial support that allows them not just to enroll, but to really thrive at your institution. Examine the admissions preferences, something that we kind of talked about earlier, such as those related to legacy status or donor affiliation, anything unrelated to an individual applicant's merit or potential, and think about the potential barriers that are, posed by existing metrics that may reflect and amplify any inequity, disadvantage, or bias. So some of the Q&A examples. So the characteristics referenced in the guidance include courage, motivation, determination. And these characteristics can be considered even when linked to race. So I have a couple examples. So one, an applicant describes what it means to be the first Black violinist in the city's youth orchestra. An applicant recalls overcoming prejudice when they transferred from a rural high school where they were the only student of South Asian descent. Perhaps there's a guidance counselor or other person writing a letter of recommendation, and they're using a description of how an applicant conquered their feelings of isolation as a Latina student at an overwhelmingly white school to join the debate team and really excel in extracurricular activities. And then we have another example of an applicant's discussion of how they learned about traditional Hmong dishes from their grandmother, and that sparked their passion for food and really nurtured their sense of self by connecting them to the past generations of their family. So what are some steps that institutions can take to achieve diversity? So when it comes to outreach, like we said, the Supreme Court's decision does not require institutions to ignore race when identifying prospective students for outreach and recruitment, provided those efforts don't provide a preference in the admissions process. So the goal of such efforts should be to remove barriers and promote opportunity for all. So factors that can be considered, you have geographic residency, financial means, social economic status, family background, parental educational level. So for example, some institutions may target school districts or high schools that are underrepresented in the institution's applicant pool. Another option is for institutions to offer pathway programs such as summer enrichment camps for students in nearby public schools. And to this end, an institution may award slots based on non-racial criteria, such as all 10th graders with a certain GPA, if you will. So the collection of demographic data. So demographic data can be used to help an institution really fine-tune their outreach efforts and determine if the student admissions outcomes do not create barriers to admission. And this data may also be helpful in assessing programming needs. So when you think about the academic, social, and financial needs of your student body, but this data cannot influence admissions decisions. When it comes to the evaluation of admissions policies, consider increasing access to first generation college students or Pell Grant eligible students. Consider whether aspects of the admissions process are inadvertently screening out students who would contribute to your campus, such as through standardized testing or certain prereqs. Racially neutral admission characteristics can also be used, such as admission to all students who graduate in the top portion of their class, or other factors related to their experience, such as the community service that they have, whether they're bilingual or speak more than one language. When it comes to student yield and retention strategies and programs, really want to foster a sense of belonging through cultural centers, affinity groups, and focus groups, or even having listening sessions on race-related topics. Those are all steps that institutions can take to achieve diversity. So some examples of OCR enforcement, if you will, that were granted. So I won't read the example in their entirety, but you have an example of a curriculum where students of different races have to read different materials based on their race. And the college also requires that students complete different written assignments and participate in discussions groups based on their race. So when asked why the college assigned the different materials, the college stated that the students often felt more comfortable reading words by authors of their own race. So in response to this, you have a student who files a complaint with OCR, and OCR has said that they would have a reason to open an investigation based on that complaint. Another example that they have where they would actually declined to open an investigation based on the complaint is in the wake of race-based violence on campus directed against Asian students. A college's Asian American Student Alliance establishes reoccurring discussion groups for concerned students, and they have a licensed counselor present. That group is a recognized student group that's open to all students. The events are advertised, and it says that it creates a safe space for students to discuss hate incidents against Asian Americans. A white student, files a complaint alleging that the college is promoting separation of students based on race, and that it's allowing the Asian American Student Alliance to establish reoccurring events for concerned students because all students who participate are Asian. And as I said, the OCR would decline to actually open an investigation based on this complaint. And I tried to emphasize the all, if you will, as a reason why the OCR would likely decline to open an investigation based on that complaint. So with the TJ case, and I know we have about 20 minutes left, and Elizabeth has a lot of good information about some of the current state laws and challenges. Just want to remind you that, before the SFA decision, the Fourth Circuit held that Thomas Jefferson High School for Science and Technology's admissions policy did not discriminate against Asian American students. The high school had revised its admissions policy in response to concerns that its student body lacked diversity. The student body was about 71% Asian American students. So the revised policy did not allow the people evaluating the applicants to know the race of the applicant, but it did result in increased racial diversity. And the Fourth Circuit ultimately determined that the new policy did not violate the Equal Protection Clause because there's not evidence that the new admissions policy was designed to achieve impermissible racial balancing or the alleged proxies for race were used. Again, that's more information about the TJ case. Want to mention the American Alliance for Equal Rights versus the Fearless Fund Management. So the Fearless Foundation, we gave out $20,000 grants to small businesses that were at least 51% owned by Black women. The American Alliance for Equal Rights sought a preliminary injunction preventing the grants from continuing because it constituted race-based discrimination, is what the alliance alleged. And the district court denied the preliminary injunction, finding that the American Alliance for Equal Rights failed to show a likelihood of success on the merits. The plaintiff appealed, and the 11th Circuit granted their motion for an injunction pending appeal. So that's where we are with American Alliance for Equal Rights and Fearless Fund. And with that, I want to turn it over to Elizabeth to talk about state law challenges and changes.
Thank you, Taronda. So let's jump in and talk about some recent state law challenges and changes in the DEI space. So as Catherine sort of highlighted at the beginning of the presentation, we have anti-discrimination policies that are often required for compliance with federal law. We have federal civil rights statutes that apply to our institutions. And then alongside that, we have state laws that are currently challenging the importance and some priorities related to DEI work on campus. So want to at the outset sort of emphasize that there's certainly differences in the state law efforts that and the state laws that we're seeing be proposed and passed. And so it's important to sort of carefully, review and analyze what those state laws are. But in general, when there are some of these laws that are being proposed and passed, the DEI efforts are viewed as discriminatory in and of themselves. They're viewed as a potential violation of free speech, or they're viewed as a misuse of public funds. And so we're seeing, again, whether it's through Board of Regents activity or associated, legislation. Those are sort of the categories that the DEI DEI efforts are viewed as. And so the state legislation that we're seeing then be enacted sort of falls into various categories, and we'll talk about some of those as we move through the presentation. The Chronicle of Higher Education has been tracking DEI legislation, and in doing so, they've used the term anti-DEI legislation. So we're going to use that terminology in sort of launching our first poll question to sort of understand what might be going on in your particular state. So if we could launch that next poll question. Does your state currently have any anti-DEI laws? Yes, no, or I'm not sure. Give just a minute. And again, generally, we're using that phrase to sort of collectively describe the laws because we're going to be discussing some of the data from the tracker. But collectively, these are laws that tend to restrict or prohibit certain training statements or offices or staff. And with that, we'll go ahead and show our results. Okay, so we're split. We have about 40% say yes, 40% say no, and then a handful say, I'm not sure. So that's fairly consistent with, I think, what's going on in the country, which is, some states do have more of these types of laws that we're discussing, and others do not. So again, we've kind of tried to, use the Chronicle tracker as a resource and sort of divide these DEI laws into various categories. So as I mentioned, some of them relate to DEI offices and staff. and have requirements or restrictions related to such staffing. Some have similarly sort of components related to diversity statements and whether those are allowable. And then two other categories, mandatory DEI training. So there are a number of states that have created laws prohibiting DEI training or that address the content that can be discussed at any mandatory training. So at the beginning of this month, 18 states in Congress have laws addressing this topic. And then the other graphic, 14 states in Congress have passed laws prohibiting identity-based preferences for hiring and admissions. An example there is Alabama's law that prohibits an institution of higher education from conditioning enrollment or attendance in a class, training, or orientation solely on the basis of race or color. Of course, this type of conduct was already prohibited under federal law, but these types of laws demonstrate the DEI perspective from the states that have passed them. So let's start with that first category, laws impacting DEI offices and staff. So most of these laws prohibit the existence of DEI offices and staff, and some institutions have then incorporated these staff members into other areas. So for example, moving the DEI office to student affairs, or moving individuals who were serving in a centralized DEI office to various other departments throughout the campus. Two examples of state laws there, Texas Senate Bill 17, which prohibits public higher education institutions from having DEIA offices. There's also Utah State House Bill 261, which was signed into law this year, that prohibits institutions of higher education and public education systems from establishing DEI offices. We've also seen state law activity in Iowa, and that's an example of, again, how there may be policies promulgated through the Board of Regents and then also through the state legislature. So the Iowa Board of Regents had a ban of DEI offices across public universities, requiring those offices to be restructured and to eliminate any DEI offices or functions that are not necessary for either compliance or for accreditation. So sometimes in this space, right, there's a tension between accreditor requirements and some of these, state legislative activities. And so with respect to that, policy, there was a recognition that there may yet be functions that are necessary for compliance, federal civil rights compliance, like Catherine highlighted at the beginning, or for accreditation. But then the Iowa General Assembly went further and introduced a bill in April this month that is now with the governor to sign or veto. And as I said, it goes further by defining DE&I offices quite broadly and saying that DEI offices are any university unit responsible for, quote, promoting activities or procedures related to DEI, and DEI encompasses any activities designed or implemented with reference to race, color, ethnicity, gender identity, or sexual orientation. So by including this really expansive definition of DEI, this could restrict programming beyond the university's central DEI offices. So again, really requires a careful analysis of the institution's mission and goals and operations and compliance, with federal law and other laws, while also looking to ensure that there isn't anything that's, running afoul of this definition, should the law finally be passed. And just one note, the Iowa bill also restricts universities from taking stands on particular issues. Any effort to promote particular positions that might be widely contested. So that's another sort of extension of that proposed Iowa legislation. So then the next category relates to diversity statements. These typically prohibit institutions from requesting diversity statements. They sometimes prohibit institutions from requiring students or employees to agree with certain statements. An example, again, Utah House Bill 261, which prohibits institutions of higher education from soliciting information related to DEI outside of compliance with federal grants. Again, that highlights a potential tension, right, between situations where that type of information is required for compliance with federal grants, but may also be areas where it's prohibited by state law. There's a similar law that was recently passed in Kansas prohibiting state universities and community colleges and technical schools from requiring prospective students and applicants for jobs or promotions to make statements about their views about diversity, equity, and inclusion. And that includes associated fines potentially of up to $10,000 for any violation. So now we'll briefly cover some of the laws impacting mandatory DEI training. Typically, these are laws that prohibit mandatory trainings, not necessarily DEI trainings generally or explicitly. And they typically include a list of prohibited topics for discussion. And two examples are Florida's Individual Freedom Act and North Carolina's Senate Bill 364. And just by way of example, in Florida's Individual Freedom Act, the language prohibited employers from requiring employees to attend trainings or programming that espoused certain beliefs. For example, that an individual by virtue of his or her race, color, sex, or national origin is inherently racist, sexist, or oppressive. And then an individual by virtue of his or her race, color, sex, or national origin should be discriminated against because of actions committed in the past. And notably, those are not typically the types of beliefs that are included in DEI training, but nevertheless, the law, explicitly, sought to ensure that those types of beliefs would not be included in training. These types of laws raised concerns about First Amendment rights, sort of similar to the Fearless Fund case that Taronda described, right? There's arguments that this type of law restricts First Amendment freedoms. And so employers and DEI consultants sued challenging this law. And the lower court granted a preliminary injunction after finding that the law was impermissibly burdened speech, and that it was vague and overbroad. And then the 11th Circuit recently affirmed, and in doing so, found that the Individual Freedom Act was unconstitutional under First Amendment free speech protections. And the court said that by limiting its restrictions to a list of ideas designated as offensive, the act targets speech based on its content, and therefore is an unconstitutional viewpoint-based restriction on speech. So that sort of shows sort of the full progression, right, of a particular state law that was passed and then challenged at the 11th Circuit. And then the final category to reference is laws impacting identity-based preferences in hiring and admission. As we previously discussed, federal civil rights laws have long prohibited granting preference in hiring and admissions on the basis of race or gender and other protected categories. Students for Fair Admission further limited programs which attempted to promote diversity by considering in any capacity race. But following the Students for Fair Admission decision and the continued implementation of civil rights laws, state laws prohibiting identity-based preferences in hiring and admission are essentially a restatement of the status quo of what is already required. And then finally, in addition to some of these broader categories that we've tried to group for you, some state laws address topics outside of these categories. Alabama has a bill signed into law that requires all public institutions of higher education to designate bathrooms based on biological sex. There's a bill not yet signed into law in Arizona that prohibits public institutions from promoting or adopting any theory of allyship. We're also seeing some DEI bills extend to classroom teaching. We had a question about that in the chat. So an example is Indiana Senate Bill 202, which has added, one thing that it did was add a diversity, that diversity initiatives have to include a focus on both cultural and intellectual diversity. and it includes a review of tenured faculty members every 5 years. And it prohibits granting tenured faculty who do not meet certain criteria outlined regarding exposing students to certain ideas. For example, a faculty member who is unlikely to expose students to scholarly works from a variety of, quote, political or ideological frameworks that may exist and that may be applicable to the faculty member's academic discipline would be potentially subject to review and consideration for tenure. So those are just some other areas that sort of fall outside of those categories identified by the Chronicles tracker. And one thing I wanted to note about the tracker, another thing that it does is it's tracking the state laws. It's also tracking institutional response to those state laws. So as you're considering decisions, really, kind of difficult, important decisions on your campus, that can be used as sort of a resource for benchmarking. Obviously, you want to be paying attention to the nuances of your own state law, but it can be helpful benchmarking to see how other institutions have responded to some of these laws and what they're doing in terms of their changes and decision making on campus. And just to briefly kind of go through a few current topics, these two slides just sort of highlight that beyond the higher education industry, right, we've also seen an extension from Students for Fair Admission. Following the decision in July, the Attorneys General of 13 states sent a letter to Fortune 100 CEOs talking about their inability to discriminate on the basis of race, including whether it's under the label of diversity, equity, inclusion or not. And so again, just sort of shows that this was an education admission decision, but had real effects on sort of state actions by way of Attorneys General's letter. And then in contrast, again, to sort of highlight some of the disagreement around this issue, there was a Colorado Attorney General letter that was issued in response to the question about whether are DEI programs used by employers unlawful following Students for Fair Admission, the answer being no. So again, just sort of highlighting the differences that we're seeing in some of the responses by states. Another topic we're seeing, of course, is institutions changing their diversity initiatives in response to some of these state laws. It's important, of course, to remember that as institutions are making these decisions, that they need to be compliant with, again, both their federal civil rights obligations and also the state laws at issue. And when changing diversity initiatives, again, some institutions are moving towards less overt DEI efforts. And, in most states, DEI initiatives remain legal. Where there are laws that may affect those DEI initiatives, again, sort of careful review of how those initiatives are being carried out on campus is important. And then, again, institutions have to comply with DEI laws in order to be eligible for state funding. So have to be cautious to review these anti-DEI laws. And when that's done, when that work is done to review them, it often indicates that well-executed strategies related to DEI may be permissible. So, consulting with an attorney, with your counsel to ensure that your institution can meet these legal obligations while also supporting an inclusive campus is really critical. And again, as we highlighted earlier, there are various sort of factors to consider here. Among them, accreditor requirements is one. So where there are these tensions between these requirements and restrictions, that careful review is really necessary. And then, so just want to conclude with some recommended practices. Reviewing admissions policies and procedures, certainly in response to Students for Fair Admission and even leading up to it, institutions were doing the important work of kind of looking to see how their policies and procedures aligned with both their missions and values and the law. Understand what practices your institution can use to legally support diversity efforts. Again, there are still, many aspects that are permissible, and so reviewing those to see how you may still operate in compliance with state law is really critical. And then considering how your institution will strategize and communicate these types of things. So what types of communications and DEI messaging are we going to put out, because it's consistent with our mission and our values and is also compliant with some of the recent restrictions that may have been imposed on us through state law. So some key takeaways, again, federal civil rights laws protect the rights of students and employees. Although there are challenges to DEI initiatives, there are many methods of ensuring access to quality education from students of a wide variety of backgrounds. We have that ongoing legal obligation to ensure that we're protecting students from discrimination and harassment. And one way to really address these issues is to conduct a DEI and federal civil rights compliance audit, again, making sure that even that audit and the ability to do it is consistent with state law requirements. Those can be one way of really evaluating your DEI objectives and ensuring legal compliance. So with that, we're concluded. We want to thank you so much for joining us today. We hope the information was helpful to your organization. As a reminder, the program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. For those of you who are on the June to June compliance year, we know that these CLEs are very important at this time. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. And again, please be sure to complete our short survey. We really do appreciate the feedback as we're trying to develop meaningful and helpful content for you and your colleagues as you're continuing to do the really important work, mission-driven work of educating those on your campuses. So thank you again. Have a nice afternoon.